All right, my next guest is a longtime friend of the program, at least my radio program, but he's been on this program, former New Jersey Superior Court judge and host of the Judging Freedom podcast. Andrew Napolitano, welcome back.
Thank you, Andrew. Pleasure to be on with you. No matter what we're talking about, it's a pleasure to be on.
Well, this is something when I make a short list, you're on it for this kind of thing. Just I had Matt Whitaker on in the A block. Give me your quick hot take, your 50,000 foot view of this FBI raid of Mar-a-Lago.
Well, my first reaction was, the president, for better or for worse, the former president, is the subject of 3 criminal investigations. Which one was this? It's not Atlanta. It's not January 6th. It's got to be the national security documents, which we now know. We know this from conversations that the FBI casually had with people that were in the house, that's what they're looking for. I'm scratching my head as to why they brought a locksmith to drill open his safe. How would the FBI know to tell a judge where this was? A warrant must specifically describe the place to be searched and the thing to be seized. They would need express permission to break open that safe. In order to get that, they'd have to tell the judge what was in there, and they'd have to tell the judge how they knew what was in there. So for this to happen, it had to be approved by Merrick Garland himself, the Attorney General, and then at least 2 FBI agents and 1 federal prosecutor, could be more, had to go to a federal judge or a magistrate judge in Miami and demonstrate under oath that a crime has been committed. Not that President Trump committed the crime, but that a crime has been committed, and that it is, quote, more likely than not, close quote, there is evidence of the crime in Mar-a-Lago and in the safe. So
no,
I'm salivating to see the affidavit that the FBI agents signed and the transcript of what they told this judge in order to induce him to issue such an extraordinary search warrant.
Some legal analysts are questioning why they just skipped a subpoena and went for this sort of, raid, if you will, to seize the moment, like you said, bring in a locksmith, drill a hole in the safe and get what was in there, the contents. Isn't this normally something you would just request?
Yes, it had been requested and denied, and then the president quite prudently engaged experienced federal prosecutors from Washington, D.C. to negotiate with a crew of experienced ex-federal prosecutors, or defense lawyers now, from Washington, D.C. to negotiate with the present federal prosecutors. They actually conducted the negotiations at Mar-a-Lago, also unheard of. The president stopped in and said hello and shook hands with everybody. And then apparently the negotiations broke down. But you're right, and the people you're quoting are right. Unless there is some reason to believe that the evidence is going to be destroyed or removed, a subpoena from a grand jury will work. So they must have, the FBI and the federal prosecutors must have told the federal judge in Miami, we have reason to believe that President Trump is going to take this out of the safe. Now, I don't know what that reason would be, but again, they'd have to explain.
Oh, really? I mean, look, he could have just burned the stuff the minute they walked out the door, right? I mean, if he had 10 minutes to himself and there was a box of documents and it was in his safe, he could have just walked over to the fireplace and tossed them in and they would never know any better. I'm just trying to think of what a benchmark for this would be. Sandy Berger took documents out of the National Archive. These were the originals. There's no way of knowing exactly what he took in totality. And they were documents that were related to the lead up to 9/11, or at least terrorist attacks that would occur around the millennium, around the Y2K and all that. He got a $50,000 fine, 3 years of probation, and lost his national security clearance. No jail time. And of course, I don't have to brief you on all the stuff Hillary Clinton did, wiping servers, smashing BlackBerries, smashing servers. Nobody's gone to jail for this.
Agreed. Donald Trump is not being treated the way Sandy Berger and Hillary Clinton were. I have to give you a footnote to the Sandy Berger thing, and it's disreputable, but it's true. I won't use the person's name. The prosecutor was appointed as a federal judge by Bill Clinton. I think that was, yes, I won't tell you who that is, but he's a sitting federal judge today. I'm sure that was part of the deal. In terms of Hillary, Look, when Jim Comey made that announcement on July 2nd, 3rd, or 5th, it was right around the 4th of 2016, we're not going to prosecute her. That is not a decision for the FBI to make. He had totally stepped out of his range, his lane. That's only a decision that the DOJ can make. So the criticisms of the FBI approaching Trump's house and the way they raided it, if you will, should be criticisms of the DOJ, because the FBI is toothless without the DOJ telling them where to go, permitting them where to go, and getting them authorization to go there. So the people who should answer for this are Merrick Garland and his senior prosecutors, not Chris Wray and his FBI agents.
I asserted during my monologue, what I call the argument, that the Congress could pass a law. They could call it the Presidential Records Act of 1978. Jimmy Carter can sign it into law. But really, they can't change the Article 2 qualifications for a president. I mean, yes, the president was impeached twice. He was not convicted either time. So barring him from office, I don't understand how the Congress could bar him from office. And I remember there was a federal judge, Alcee Hastings, that was impeached and convicted, and he wasn't even barred from office, and he ran and won a seat in the Congress.
Right. So Alcee Hastings was a federal judge who was impeached after he had been prosecuted as a sitting federal judge for bribery and acquitted. And he was able to run for Congress. I think he's no longer living, but he was in Congress for 20 years. Here's how Congress could interfere with Donald Trump running for president, Andrew. I don't think this has been articulated before, and this has never happened in American history. If you read the 14th Amendment, it says no one shall be qualified for federal office who, while in office, had been engaged in an insurrection. Not convicted of being in an insurrection, but engaged in an insurrection. It doesn't say who will make that determination, though it's in a clause of the 14th Amendment that deals with the powers of Congress. And it doesn't say how that determination would be made, by a trial, by a vote, by a 2/3 majority. It doesn't say. But I am sure that that is probably in the Democrats' bag of tricks. Now, that's the other investigation. That's not this thing about classified documents. That's the other one. If Donald Trump were to be prosecuted and convicted of the wrongful possession of classified documents, which Sandy Berger got a slap on the wrist for and Hillary Clinton wasn't even prosecuted for, that conviction as a convicted felon would keep him off the ballot for president in some states. The Democrats know that.
Okay, so the states might have a way of blocking him, but the Congress can't change Article 2. Let me just, one thing about the 14th Amendment. If no one was prosecuted under 18 U.S.C. 2383, the insurrection charge, how would they get away with calling it an insurrection?
I don't know the answer to that, Andrew. This has never happened. I'm trying
to impress you here. I'm a non-lawyer. I'm not a judge.
I know, but I'm trying to put my brain into Chuck Schumer's head. It doesn't fit.
It does it seem like, because I was during my monologue, Andrew Cuomo went on, shockingly, Andrew Cuomo had questions about this and said, this better not be political. And Andrew Yang said the same thing. There have got to be, I've only got a minute left, there's got to be a few Democrats that are like, you're playing with fire here. If this blows up in your face, he's going to run and he could win.
Agreed. And my view is, and guess is, since I know the Attorney General, he's too smart to allow this to be political. There must be a there there. If there's no there, this will blow up in the Democrats' faces.
Well, look, again, I know it sounded sort of silly, superficial to say a napkin with the tic-tac-toe design on it, but if this is trying to revoke his license for going 56 into 55, I don't think a lot of people are going to buy this. I mean, if he's got nuclear secrets and he was selling them to the Russians, I'd turn on him.